Welcome to the live stream tonight, everybody. Advocates for Justice Paralegal School. I'm Coach Neighbors, and tonight we're going to be talking about some things that you all need to know if you're facing a non-judicial foreclosure process. So let's just get things lined up here. If you guys are coming from Facebook, please go to this link and give StreamYard permission to use your name, to use your Facebook username. So when you comment, we can see who you are. And if you don't go to that link, you can just say, hey, this is so-and-so. So if you make a comment and you're showing as Facebook user, you can let us know who you are so we can know who we're talking with. Welcome to the group tonight. Welcome to the show tonight, group. We're not going to go real long. I haven't been feeling too well today, but we're getting it done. And no, it's not the virus. I think I ate something, but I don't know you guys. Well, some of you I don't know close enough to discuss my. Okay, never mind. Let's move on. Yeah, but we're getting it done. We're going to touch today on the non-judicial foreclosure process, and I'm going to outline the one step that a lot of people are missing, that's putting you too close to the edge of the cliff. Welcome, Facebook user. What's your name? We don't know what your name is. Follow that link at the bottom of my stream and give them permission to give StreamYard permission to use your name so that we can see who you are. Welcome to the show tonight. Yeah, well, you know how it is. When it got to get done, it's got to get done. So, yeah, I'm feeling better. Just that I would like to be chilling a little longer, but we got to get it done. We ain't got time to be playing. And I'm the last one that's finna go sit down because I never was trained how to do that. So, yeah, coach, you're looking, no, coach, I'm good. Until the end of the game, I need ice. So let's just get started. So I'm Coach Neighbors. You guys know who I am. Tonight's live stream, going to cover the non-judicial foreclosure process and what you need to do to stop the eviction part of that process. And that's kind of what we're going to focus on. That's the main focus that we're going to focus on tonight, because I see people are not doing the one thing that we need to get done to control the state court process. So you get yourself out on the 50-yard line so you can throw some passes in the end zone. So we'll get back to that. We're going to update you on the thing, the thing that we talked about last week, because I can't say the thing. I can only say, well, the thing. I can't say the exact thing, but you know what we're talking about. We're going to update you on what we're doing with the thing. And also, if I have time and I don't run out of gas, I'm going to update you guys on my sister's terminated judicial foreclosure that she moved over to federal court, and whatever else comes up. So let's just get started. The non-judicial process. Now, I'm just going to say, my research have shown me what we're talking about now. Okay, I'm not an attorney and I don't know stuff. We're all stupid. Only attorneys are the ones that are smart. But I know stuff from working with you people in the group, working with all of you guys. So we're going to talk about that. So the non-judicial foreclosure process, in my opinion, was put on the books as a way for these people to have to process a vacant home. Think about it. A lot of states have both. And I think that so they put this on the books to process a house when the people just pack up and leave. And we don't know stuff, so they just started using it in some states so they can hurry up and get people out. And that whole process is in violation of your due process and some other stuff. But I like to just keep it simple, because if we get to talking about too much shop talk, it'll be like blah 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 to everybody's ears. So to some people's ears, not everybody, some people. So let's just break it down. So the non-judicial process starts out with them mailing you, and if I'm off base here, somebody chime in and let me know. The non-judicial process starts out with them mailing you a notice of default letter. And that notice of default letter, they tell you you need to pay the full amount in 30 days or they're going to sell your house. And they're using the power of sale clause in the deed of trust to give them authority to sell your house and bypass the court. Now, we already know that the Constitution mandates that before they take your stuff, they need to drag you in, that you need to be in court and all of that. No, what Constitution are they? They're talking about, because they're not using the Constitution. And if you stop and think about it, that power of sale clause in the deed of trust, nobody knows about that. Nobody signs that. I mean, if they told me, okay, I need you to sign right here for this loan, it's going to take you 100 million years to pay back. Oh, and by the way, if you go into default, I need you to sign right here this power of sale clause, giving us the authority to sell your house without going through court process. Who the hell is going to sign that? Yeah, I'm not signing that. So no one would sign that. So it wasn't disclosed in the contract. And I'll tell you right now, when I was fighting for my property a bunch of years ago, while I was learning all of this, when I was fighting for my property, one day I read the entire mortgage contract, and dude, wow, you agreed. I agreed too, but I'm gonna say you. If that's all right, because I like to. Yeah, you agreed to pay all of the other attorneys' fees should you go into default. Not if you lose in court, if you go into default. Oh yeah, they don't point that out to you either. And I could spend the whole time talking about this. So the money for this alleged loan that they're talking about was generated with your signature on the promissory note. They process it through the Federal Reserve for electronic credits, and Money and Modern Mechanics publication states that they were granted 9 times the amount that went into that demand deposit account with your name on it before they wrote a check. So that whole process is yeah. We avoid addressing that process by going out to them for violating the court, for the court violating your due process rights. So now you have 30 days to pay in full. But what they don't tell you is the law states, and GLADSTONE, you can attest to this because you have a copy of that letter. The law, the offer to pay letter, the law states that if they're going to call in their loan and expect you to pay in full, they have to provide the original instrument of indebtedness in its original form. And they can't, because they don't have it. So that letter, offer to pay letter, is going to be part of the program that we're building for the people to challenge the thing. Excuse me, the thing. I almost said that's all right. The thing. I can only call it the thing. Y'all know what I'm saying. I'm talking about the thing. So you got 30 days to pay in full. And most people at this point are all freaked out. Yeah, and rightly so. Rightly so. But you know what? Being freaked out ain't helping you none. So don't waste no time with that, because it just creates drama. You need to figure out how to get this done. So the next thing they tell you is, oh, don't worry, go home and relax. Send us a copy of your bank statements and your paycheck stubs, and we're going to see if we can get you hooked up for a loan modification, because I think we can. Yeah. Well, they're full of crap, and the whole time they're telling you this, they're running you out of time. They're running you out of time. They're running you out of time to fight. Remember the 30 days? Now, with that being said, and I say this, and some people look at me like, oh my God, the most important thing is not stopping the sale. That's not the most important thing. The most important thing is having a game plan in place that's going to block the eviction process. Okay. Now, with that said, you can have a game plan that block the eviction process. And if you block the eviction process, obviously you're going to block the sale, right? But you can block the sale without blocking the eviction process. And if you do that, they're going to call a timeout, throw your shit in a basket, and let it set. They're going to stall and let it set because they need to get you to that eviction date. And that's what they're going to try to do. They're going to throw it in a basket and they're going to just let it sit. So you guys have to be on your toes. And a loan modification. So here's the thing. There's a thing. If they wanted to help you, they would not have foreclosed. So that's, if they wanted to help you, they would have not have foreclosed. They would have said, hey, let's do a loan modification. Bring us in your stuff because we don't want to foreclose and freak you out and have you running around. But that's not what they said. They sent you the letter that you had 30 days and they're going to sell your shit. And they do, unless you do something about it. And we're going to get to that here down the stretch in a minute. So they tell you that we're going to see if you qualify for a loan modification. Send us this, send us that again because we didn't get this. You guys know what I'm saying. Next thing you know, they're putting a sign on your house. And that is the beginning of the eviction process. After the sale, they take you to court for the eviction process in the non-judicial foreclosure. Now, here's the problem. The problem is most people in non-judicial foreclosure they sit around and wait until they get into court. It's too late. Well, it's not too late, but it's too late. You can't sit around and wait. That's a hard road to go because you're right on the edge of the cliff and they're kicking you in the face the whole time, throwing your stuff on the desk in the basket, ignoring your calls. The judge has got coronavirus and having the transplant, all of those lies. They just need to stall you off to get your butt into the eviction protocol. Now, the smart thing to do is to file your 42 U.S.C. 1983 civil rights lawsuit against the state. You always want to add the state because the state is the one trying to steal your property. We'll get into that in a minute too. You always want to add the state. You want to add the attorney and the law firm. And if you're in the eviction process and you got some fools trying to steal your house, you add them too. We used to stick with just 3 people, but our program is changing as the need changes. Thank you, Lori. Welcome to the show tonight. Welcome, Waverly. I saw your message to me over there on Facebook, and that's where you're supposed to be, but I'm kind of busy right now. So and you can see. Welcome to the show, buddy. I like to make sure everybody gets a shout out because I sure appreciate you guys taking the time to share your time with me. So after the sale, they take you to court for the eviction process. The eviction process is done generally in a lower court that does not have jurisdiction to hear a title dispute. And I'm going to explain to you how that goes. The eviction process is a trick bag structured to violate you. The eviction court does not have jurisdiction to rule on a title dispute. So if the eviction court does not have jurisdiction to rule on a title dispute, why the hell are you in their court? In most places, the eviction court is municipal court down the street. and the same court for traffic court and all of that. Now, has anybody ever wondered why the hell municipal court is down the street and not connected to state court with all of that? Well, I did. And eviction court, and if you don't believe me on this, you can look up the court clerk's manual for your state and see for yourself. The eviction court gets its jurisdiction, municipal court gets its jurisdiction from the city ordinance. Yep. I'm like, when I read that, I'm like, what are you kidding me right now? What corporation can give yourself judicial authority to be doing stuff? And if you read the clerk's manual, it'll tell you right in there that the court don't have jurisdiction to do anything. It can only hear money stuff, and they can't make any determinations on the money. And when it comes to that, it's supposed to be the money. If it comes to making a determination on the money, it's supposed to be sent back over to state court. All of that is in the manual. But no, that's not what they're doing, because nobody takes the time to see the manual or until now, to do something about it. What do? You can't hire an attorney, or you can hire a coach that don't like them fools. I ain't got no problem. Can I say punching them in the face? No, I can't say punching them in the face. I got no problem not punching them in the face. I mean, punching them in the face. All right. Yeah, my legal team they don't like me to get too excited because I start talking about doing things to people. So the eviction process is a trick bag, and I'm going to tell you how it goes. You go to the eviction court. The new thief comes in. The thief comes in with the new fake, fraudulent property deed, and the judge says, "Sir, new property owner, do you have the deed?" "Yes, I do, Your Honor. It was released to me, last year." It was released to me, and yes, I have the deed. And so now they're going to look at the property owner, and he has the deed, and the eviction court can only make a determination on immediate possession. That's it. Immediate possession. That's what they're doing in eviction court, setting you up to make determination on immediate possession. Now, to give you an idea what the hell I'm talking about, if you showed up to eviction court with your deed, the one with your name on it, what do you think the judge is going to say? "Oh, we can't rule on that because that's a title dispute." "Oh, but you can rule on it if it's for those fools over there that paid him." Okay. All right. I'm assuming that they paid him. I'm pretty sure they paid him. Okay. You're welcome, Waverly. I'm getting distracted, so I need to stay focused. So they violate you with the trick bag, and now I say the only, and that's where we're at now. But we did have a plan for this before we got to where we're at now, and the plan we had for that was we would file your lawsuit in federal court and then remove the whole state court eviction process over to federal court to be connected with your lawsuit. That's how we were doing that. And it was kind of a hit and miss, because the people who are okay, I'm working with it. The people who are buttheads and not having their crap force them to do the right thing. The soft people who are nice and think that there's rights, that they have rights, or that they have to listen to them people. Okay, those people, a few of them didn't get it done right. So now we have a different program that we're doing, and we learn how to cut to the chase. So now we're just going to start suing the judge. If the judge signed on to the case, what we do welcome, buddy. Welcome to the show tonight, Dalen. Yeah. So we're going, thank you. Welcome to the show, Jim. So what we need to be doing is cutting to the chase. That's what we're learning how to do. The 42 SC 1983 Civil Rights Lawsuit Package can help you by attacking the players for violating your right to due process. And I also addressed the Administrative Procedures Act of 1946, the foreign agent registration issue, all of those things. I don't really focus on those things a lot because to most people, they're just blah, 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 because most people don't understand don't understand what's going on. So I don't really focus on all that. So is and with my stuff, you're going to the table with stuff they don't want people to know about, and you're addressing their violating your rights with their illegal processes and procedures. Now, this is something that I want to tell you guys, and this is important. Most people call me, some people call me, and they're still talking about the damn lender. Okay. And so those people I want to send, I'm just saying. Now, with that said, some people don't just found me or whatever, but if you've been on my channel for a while and you email me or message me and you're talking about the damn lender, then I'm going to ask you to go back there or something, because it's not the lender. People it's not the lender. And I'm going to tell you, you want to know, this is my opinion from my research. You want to know who's trying to steal your property? The state. The state is the one trying to steal your property. And when we add the state to this, if they're trying to steal your property and you're in eviction court or just in court, then you should take that 42 USC 1983 Civil Rights Lawsuit Package and title the top of it for state court and file it as a counterclaim in their case. After you add the judge, the state, and the attorney to their own shit and file it in their face. There you go. That's how we do it. And when you do that, that's a problem. Okay. That's what you need to do to get yourself out on the 50-yard line where you can throw some passes in the end zone. That's what you need to do that. And once you jam them up, it's going to take a minute for them to figure out how to get from underneath that. And then you step over and get your lawsuit filed in federal court. And then you can use the removal document in the package to remove all of that state court crap over to federal court as evidence. I just asked them, could you guys please, the state court clerk, could you please shoot my file over to federal court? I need to ask the judge. That's how we do it. Yeah, whoever signed to begin the complaint, and Gladstone, we're going to take it a little step further. Whoever signs to further the situation. Okay. So when they send you this thing and it's signed by an attorney and a judge, 1, 2, well, excuse me, 2, 3, because 1 is the state. And if you really want to be a badass, then, if you really want to be a badass, then you should add the State Bar Association right underneath the state before you get to the judge. Yeah. So now you're still in the State Bar Association. They're not going to be able to get any attorneys to help them. And we already have that problem. And that was the problem that we created with the old package that we were doing, the $400 package. We were creating a problem with that $400 package because we're suing the players, and the players can't represent themselves in court. So now the players have to hire somebody, but nobody wants to help them when they find out that you're going after their asses for what you're going after them for. And the reason why, and this is my opinion, I've been doing this a minute, and this is my opinion, and the reason why they're not going to help them is because they're doing the same shit. So I'm just saying, there, I said it. So how's that going to work? Um, Your Honor, this attorney is disqualified because they're doing the same thing to people over here, so they can't represent somebody when they're dirty. I think there's a doctrine for that. Yeah. Lori, I'm going to let you figure that out. So I'm just a coach here to point you in the right direction, and you got to figure the rest out. I don't tell people exactly what to do, so you got to figure out who, what, where. I'm just telling you in general. This is what I would do because I see this working. So the state is the real corporation stealing your property, and I'm going to explain to you why I'm saying that because I don't like to say stuff and then not make sure that you understand. So if you stop and look at the court situation, the judge is going to make the determination on whether or not to give your property to their attorneys, right? Um, so who's paying the judge? Who licensed the judge? Who licensed the attorneys? Well, attorneys don't have no damn license, but they say they're licensed by the state. So if the judge is paid by the same corporation that's in control of your property deed, that seems like to me that would be a serious conflict of interest. Oh, wait, they're in control of your property deed because they tricked you into thinking that you had to register it in their office. And there's no law that says you have to register your deed in their office. So that whole thing is ridiculous. There's no law that says you have to register your deed in their office. And people don't realize that the very first illegal lien that was put against their property was the mortgage lien. And the reason why, if there were several people who owned property, all of those owners would have to be present to sign the mortgage lien, right? Yep. So the fact that the alleged lender accepted your signature on the mortgage lien proves that you own the property. Bam. I know, think about it. I always tell people I play football in college and I boxed after college. Those are two things that smart people do. So we like to keep it simple. We keep it simple. You want to set yourself up so they are not interested in arguing. Now, when you add all of that crap that they think that you thought you should add before you found me, that opens the door for the arguing. They'll argue that crap and forget about all this other stuff. And then now when the arguing's over, everybody just gets to help them. Yeah, but that's what this whole process is set up about. Everybody thinks it's about foreclosures. Everybody thinks it's about property tax. People tell me, no, I can't use that because mine's a judicial foreclosure, or mine's a non-judicial foreclosure, or I'm in a property tax, so mine's different. No, it's all the same. Okay, when you get control of your deed, you should not have these problems because they have access to your deed in their office, and that allows them to file a lien on it. Now, if my property deed was stored in my gun safe, my fireproof gun safe, they would have to ask me, can they see my deed to be able to put the lien? Well, you know that's not going to that's not going to work out for them. I'll be like, yeah, sure. There you go. That's it. See ya. Don't want to be you. So this whole process, Dylan, is designed to get control of your property deed. That's what this whole process is designed to do. Now, what we're doing when people back them in the corner with the 42 USC 1983 or whatever you're using, when you back them in the corner and they have to ask for a continuance, that's when you want to send them your email. This is my settlement email. Look, guys, this can go away. I don't really want to be here kicking the judge's butt in court and suing the judge and getting the judge's bond and all of that. And you guys can see that everything that's going on here is totally illegal. Now, this is how the program usually goes because people don't know, don't fight. But my legal team ain't having it, and neither am I. So if you want to continue, we can. What I would like to do is have you guys deliver my property deed to me as mandated by the state law. I would like you to contact the credit reporting agency and remove the lies that you told them about. Yeah. And I would like to make sure that debt's discharged so it's not passed off to the next attorney. I knew I was going to say something. So it's not passed off to the next attorney. I wasn't going to say asshole. I was going to say attorney. And then the issue of the financial compensation for what they put you through. Well, some people call it a warranty deed, the trust deed. I don't know. They call it all different kind of stuff. So I don't really get stuck in the word. So, but you guys know what I'm talking about. Okay? You need to get your deed out of their office. And we talked about that last week. If your deed was not in their office, would they, the thing, would they be able to verify that you had a mortgage loan if your deed's not in their office? I don't know. I'm not smart enough to figure that out. So the thing, let's talk about the thing for a second. The thing. Oops. Closed up the wrong thing. So we're going to talk about the thing. Now, last week we talked about the thing, and we wanted people to brainstorm, come up with ideas that we, can use to figure out a package where we can challenge the mortgage payments, challenge the mortgage lien before you're in default, while you're still paying, and if that can be done. And one of the things that I'm actually in the process of doing right now, I'm putting together a lawsuit package for real estate deed fraud, because that's what it is. It's real estate deed fraud. So we're going to use that package in that document in the package, along with the offer to pay letter. And the idea is to use the offer to pay letter to jam them up into, yeah. So, and the offer to pay letter is actually an offer to contract with them. And it's letting them know that you're willing to pay the full amount that they're asking for as soon as they follow this statute. And I have the statute right in there. Not very many people know about this statute. The statute is right in there that mandates that they have to provide you the original instrument of indebtedness in its original form at the time of the thing. So in the offer to pay letter, you're asking them to sign a contract to agree to do the thing. So you're telling them to sign a contract to agree to agree to follow the law and give you the instrument of indebtedness, because at the end of the day, you should have that. So no other collectors or lenders, or okay, we'll just stick with those two, are in your face after you get done beating their face with this stuff. So that's one of the things that we're going to get implemented. We're working on right now. I'm probably going to add some more things to it, but I'm not really sure. And when I get the package put together, I'm going to be working closely with people that are investing in it so that I can see if there's anything that needs to be added or changed or whatever, like I did with the other lawsuit packages. Although I don't plan on having to have 27 documents in it, like the non-judicial foreclosure, but well, you guys know how I roll. I'm ready to put in it whatever I need to make sure that it's getting done what we need to get done. So, and I'll keep you guys updated on that. Now, my sister's case, we have it in federal court. We actually moved their state court case to federal court. And once we got the sale date dismissed, then we went ahead and filed her lawsuit for $20 million instead of $5 million in federal court. And we added the attorneys to the lawsuit, and my sister also claimed the attorney's house, the attorney's property as in her damages. And my sister served the attorney's wife because her name was on the property deed that we're going after. And they got really mad. I think I told you guys in one video they called the police on my sister and having the police tell her to not mail any more stuff to their house. But it's okay for them to mail shit to your house. Yeah, I don't like it when the shoe's on the other foot and it stinks. But that's what she did. So we're going to donate their property to the Boys and Girls Club. I'm serious. Oh, you guys know I don't play. I do not play. So yeah, we're donating her property to the Boys and Girls Club. So the attorney, thank you, Amy. The attorneys a couple of weeks ago filed a motion for sanctions against us. It was the pre-filing of motion for sanctions, where they and the city's bond as well. I have my sister contact the insurance company, contacting the city to get the insurance company information so we can contact them directly. And so the goal here is obviously turn heat up on their asses. So, when they start asking them to stall and need more time. So here's the thing. The judge that we filed, she finally hired an attorney, and we checked because we don't play. And the attorney is he has passed the federal bar. Now, the other state attorneys have not passed the federal bar and have not hired a federal attorney to represent them in federal court. So we've already addressed the fact that they had no standing to be trying to help anybody in federal court because they have not passed the federal bar. And if you want to get technical about it, now you're talking about getting spanked up in the face. I can say face, right? If you want to talk about getting spanked up in the face, if you want to get technical about it, anything that they file is we rule to dismiss because, okay, so here's how it goes. Federal case law can be used in state court. There is no difference between using federal case law in state court than there is using Supreme Court case law in state or federal or the Supreme Court. They don't like it, but who gives a crap? There's nothing they can do about it. So now automatically you trump whatever they bring to the table with state court case law in it. See, that's what I told you. We don't play around. So we use their stuff to stick right back in their face. How did I do that? I did that good. Up there in their face, excuse me. So we're going to leave it in their face. Okay, that's what we're going to do. So the state is the one stealing your property, and they're the one that's in control of your property deed. They have your property deed. They sent you a worthless copy, it's illegal for them to copy a security, but they did anyway. So that's like counterfeiting. I'm just saying. Yeah, we done our homework. So the state is the one stealing. I'm going to keep on saying that because some people ain't figured that out yet. The state is licensed. The state licenses the judge. The state licenses the attorney. The state licenses the sub corporations that are coming after you, all licensed by the state. Oh, no. Nope. Well, they don't have to because most of us show up to court and we're freaking out. And I was talking to a lady one day and I told her, I said, when you go to court, you have to speak loud. So you got to speak loud. You want to speak loud so they can't hear your knees clanging together under the table. And she looked at me with this serious look. And she said, are you making fun of me? And I said, no, I'm not making fun of you. I'm talking about myself. Okay, and I'm 6'7", so my knees are almost to the top of the table, okay? So they can, so that's just the way it is. But you need to park that at the curb because you're not going to be able to get anything done with all of that. And they can smell that fear and the fact that you need to breathe in that paper bag a mile away. So the state is the one stealing your property, and that's why we add them as number one defendant. The other reason we add the state as a number one defendant, because that helps set you up with the 42 U.S.C. 1983 civil rights lawsuit, and then you just drag all the rest of them fools along with the program in the poopy. So that's how you do that. Add the state, opens up the door for the 42 U.S.C. And now it's, you guys can go to my website at winningcourtnow.com, and you can look at, I posted some new reviews, and I also posted those reviews in Facebook. People that are using that package, people that have used that package to stop the process. Venus, she used it, and she was facing a property tax lien foreclosure, and her and I were butting heads because she wanted to go after the foreclosure, and I told her she needed a property tax because the property tax is the issue, not the foreclosure. If you stop the issue, then you stop in the rest of it, and she wasn't not hearing me. Finally, in the end, she did it the way I asked. Well, actually, finally, in the end, she did it the way I asked her, and she filed the 42 U.S.C. 1983 package, and she filed as a counterclaim in the state case, in the state eviction process. And the judge asked her, she said the judge would not let her talk. I mean, I cannot imagine the judge stopping her from talking because okay, so now the judge would not let her talk and asked the attorney if the attorney had the deed. And the attorney said no. And the judge said, well, the case is dismissed, and told the attorney that they need to start over. So, and she wrote at the end of that she was sitting there in court crying like crazy because she get to stay in her house. And she did a great job. And then I let her know that it's not over yet. She still needs to get moved in the federal court and drag their butts over and make them tap out and put them in a position to send them your settlement offer. So the deal is to control the state court process. If you don't sue the judge, and this is a step that most people are missing, if you don't sue the state court judge, the federal court is just going to drag their feet. Hey, Venus, the genius. Yeah, look at you go, girl. Welcome to the show. You're a little late, so we might have to make you run some laps. Okay, never mind. You're still in your house, so you don't have to run laps, okay? So the goal is to control the court process. And we do that by going after the people that's further in, who signed, that's further in, and people call me, ask me, oh, I have 14 this, and all these people do. Whoever, there's only one person that signed to do what they're doing right now. Those other people are just there to muddy the waters so that you're confused, and when you add all of those people to your list, and they know you don't know what the hell you're doing, and they're not going to have any respect for you. So that's all the value I'm bringing to the table tonight, guys. Went over this a little longer than I wanted, and I need to go lay down. So I appreciate you guys sharing your time with me tonight. That 42 U.S.C. 1983 civil rights lawsuit package. I posted it on my page, winningcourtnow.com, and it's also posted on the homepage. So you guys can go there if you're interested in that and get what you need to take control of the situation. Thank you guys for sharing your time with me tonight. And I will see you guys in the next video.